They're a major and you.
But like, you should be able to not do that. If
So,
you want, it's high school.
I'm going to kick off this meeting now. This is, I believe, the 11th in a series of public hearings that the State Supreme Court Access to Justice Commission has sponsored starting last August. And the first 10 were held in conjunction. David is on the Access to Justice Commission with me. We're, I think, co-chairs of this group, but David was also the chair of an ad hoc committee from the state bar that was studying legal deserts, and that committee was called
EGAD Virginia,
which stands for
Entry, Growth, and Distribution of Virginia Attorneys. We like
Because-
acronyms.
believe it or not, except maybe in this area, we have too few attorneys in the state. And parts of the state where there are way too few attorneys. But anyway, what we're doing is trying to solicit information from the public. You know, lawyers think they know everything, but they only know what they know. And we don't know anything about the experience that people have with the legal system who are perhaps unrepresented, right? The lawyers don't even know them. So what we're trying to do is get information about mostly what's not working, raw data, and we're finding themes, you know, whether it's in rural Warsaw or Abingdon or in Danville or Richmond, there are sort of recurring themes that are coming up for us. And so we will produce a rough draft sometime this year, maybe later in the year, a final report of what we heard. We can't promise change, but we can promise at least attention to the problem, which is a prelude to change. And I'm required to tell you that that's the exit. There are two exit, like the flight attendant, there are exit doors to the left and the right, and the men's and women's rooms are off to the right. Feel free to help yourself as we talk to refreshments. There are liquids in the cooler. Pizza will be showing up soon. And
we're live streaming this on 2 platforms. So far, we are the only people on either platform. But maybe some will tune in. And also, one of them will be a recording of the State Bar Committee has a YouTube page, a channel where we're posting all these, so you can go back and listen to them after the fact.
right. So the way that we've handled this in the past, not that we don't want to hear from lawyers, but we would really, I don't know, maybe he's here to see a kid.
That's the clerk.
Oh, no, he's not here to see a kid.
Somebody wants to speak to that.
Coming around the back. All right, that's great. That is very exciting. Okay, great. Hi, how are you? Help yourself to refreshments. We are kicking off. We're live streaming. We're going to hear from members of the public first, and then we would love to hear from other people who showed up about what their views are on what the legal system, particularly on the civil side, and the court system could be doing better in the state. And I don't think there's anybody here who needs a Spanish translator, but we have one on standby. I think you're not a lawyer.
No, I was a.
Would you like to come talk?
I didn't really figure.
Well, if you want, you can wait. And also, I do have there's a sign-up sheet going around. I do have note cards up here if you want to make note. You're welcome to. Okay, who would like to talk? Go for it. Come on up, introduce yourself, and
I didn't prepare.
no.
But
My
I
guess
think
is
I'm
that
doing
your
it.
life has
Yeah.
prepared this for you, has prepared you for this.
Okay. I guess I just was hoping to highlight just a real access to justice gap that I've noticed over the years that my name is Mary Horner.
Okay.
Sorry, I am here on behalf of the City of Alexandria Office of Housing.
Great.
I am not a practicing attorney any longer, but prior to this role, I was an attorney at Legal Aid for 6 years. And then prior to that, worked in representing condos and HOAs and clerked for the City of Alexandria. So I do have a legal background, but currently here in a different role. One of the things that I noticed both at my work at LS&V and currently is just a real gap when it comes to landlord-tenant issues, particularly representation for tenants. I know that throughout the state, landlords, there's a varying level of representation, but here in the Northern Virginia area, the majority of our landlords are represented by because they're large corporate conglomerates, I think over 90% of our landlords are represented. So it's a very different legal atmosphere when you're going to court here for an eviction case. It's incredibly quick. Obviously, the law is drafted that way, but because they're usually done somewhat correctly the first time, we don't have some of the legal defenses that are available to residents in more rural areas if they do have legal representation or are able to ask for a trial. One of the needs, of course, is that, we oftentimes residents go to legal aid. That's what they're told to do, but the volume doesn't match. Obviously, the need and the amount of attorneys that can help do not match. One of the things we've also struggled with is finding pro bono attorneys who have the knowledge base to take on these cases. And then if we are trying to recruit them or train them, it is then usually falling on legal aid to do that training as well. So you're either doing the training of the attorneys or or trying to represent yourself. And so there's a lot of limited capacity that we keep piling on to our legal aid organizations. And I've done a lot of research through the BBA, through other organizations that provide CLE materials, and I can't seem to find really anything that's canned that would be available on BBA to purchase if you wanted to teach somebody how to do these, just a simple landlord-tenant case. It seems to be a gap with what we can buy, what we can purchase. Someone would have to develop that, and I think that that's a real area for partnership, both on the private and the public side, not just putting it all on legal aid, and maybe having something at a more statewide level. So that's just one of the things I wanted to highlight, is that I think there's this also push for right to counsel, but that's going to require this training. That's going to require a lot of moving forward and making it so that it's not just legal aids who are teaching people how to take these cases. Again, we just don't have, I now work for the Office of Housing in the Landlord-Tenant Division. We get calls from the broader public who are having landlord-tenant issues, and there's also a gap there, right? You either go to court or you have nobody.
Right.
And so we try and fill this gap where we are providing information, but we can't give legal advice, obviously. So we're trying to help, but you end up troubleshooting without authority. And so there's, I know other states have looked at potentially allowing non-lawyers to assist in court. I don't want to take anything away from lawyers, but we don't have any lawyers who are doing these cases anyway. So, if there's something we can do to maybe limit the barrier of who can help, because we have a lot of people who are interested and willing to help. They just, either they don't have a law degree, even though they have the knowledge, or you have a law degree and you need to go make money, so you're doing something else. So it just seems like there's this really a crater where we have this an incredible amount of need, and a limited amount of training would help, but we keep putting it all back onto the same resource to do it.
So maybe I could interact with you later. There's an attorney who retired from legal aid after about 40 years in Richmond named Marty Whitewright.
Yes, I know Larry.
And Marty has amazing materials.
Yeah, so I guess it's just like updating them, making sure, because someone has to every single year. But yes, if we can make those available through.
Well, he was updating them every 20 minutes during COVID.
Yes, during COVID, we were all on.
Yeah, it's like every month it would be a new.
It would show, and I think that shows us what we can do. Right. When we're all putting our attention during COVID, everyone paid attention to evictions, and here we are, kind of post COVID. It's back to normal, which is really bad.
Right.
So I just wanted to highlight that.
Right. Thank you very much.
Yeah,
Appreciate it.
We generally have an old-fashioned training model, which is in person or not at all.
Right. And so if there's things that are canned that we can create that live on and just need to be updated annually, that's just something that maybe we could all partner together to do.
So have you seen in this area, when I have done, for instance, in the old days when I volunteered with the DC bar for a particular clinic, they would have online training that you would take, and then you would have access to ask somebody questions afterward. Is that something, I guess that's hard to get CLE credit for in Virginia. It's a good way to transfer knowledge.
I'm sorry for interrupting.
Yes, sir.
I'm the incoming president of the Bar Association.
Good.
And we are
Please,
doing our best to.
please feel free to actually introduce yourself.
Sure.
Yes, please.
My name is Wirt Brock, and I'm the incoming president of the Bar Association.
For Alexandria?
And, right, Alexandria, correct.
Great.
And I know that we are trying to institute trainings for several things. I know Mary's big deal is the eviction defense, pro bono eviction defense, what we're hoping to get started with. pro bono divorce and pro bono help getting people's licenses back and
Mhm.
other types of things. There's a training aspect to it, which we're hoping to get going this October through our CLE marathon. We do both a paid CLE marathon, and we're hoping to roll in more pro bono trainings for that. And then it's just a matter of trying to find the resources through legal aid or whoever to vet the people that are coming through the system. It really seems to me that the people that fall through the cracks are the people that can afford the lawyers, the people that can't afford the lawyers, and the people that are right in the middle. And there's not a really good answer for them. I mean, sometimes I tell people, like, you might be better off calling a lawyer in Roanoke because they might be $100 cheaper or something. But, you know, unfortunately, life in Alexandria is a lot more expensive than life.
So let me ask you a question, and not to put you on the spot. Can you tell me more or less what that range would be on it for an attorney on an hourly basis to do an eviction case?
Eviction case, I think you're going to have a hard time finding people that want to do it on the.
Okay, how about
The
any kind of
evictees,
housing case?
Right, yeah, that's
I
a
mean,
different
let's
story.
broaden
Right,
it.
right.
Yeah, I'm asking that because David is the director of legal aid, and I worked in-house, so we never actually have billed
My
clients.
understanding is in Fairfax, and I'm probably the wrong person to be speaking to this, but it's Legal Services of Northern Virginia has a program that they run through. I don't know if it's with the Virginia Bar Foundation or Virginia Bar Association or State Bar or whatever, but I know that there's a kitty of money that is helping to pay lawyers on a case-by-case basis, but they have to get the training, and then as part of getting the training, they have to volunteer.
It's a
for couple
low
of
bono?
cases.
Or,
It's low bono, but it's through Pathways. It's through another, it's a nonprofit
Yeah,
that
it's
hosts the
not-
Oh,
money. We just
Pathways,
provide
okay.
the, we provide the training. It's not LSNB. They just provide the training.
but I mean, I don't even know what a market rate is for an attorney, I guess, locally.
Locally, I think it's a huge range.
Yeah.
And I think you'll probably, like, I'll give you a for instance. I had a court case with Judge Tran in Fairfax a couple years
Yeah.
ago. And in that case, I think my rate, this would have been probably 8 years ago, my rate was $250 an hour.
Okay, so
And Judge Tran told my client on the record
that was a bargain.
that he got a really great result with a lawyer that charged him what paralegals charge.
Yeah.
And I said, well, I think my rate's too low. And so currently, you know, I think for you have young lawyers that are coming into the market that don't know what the hell they're doing, that are charging $500 an hour. You have older lawyers that feel like $500 an hour is highway robbery, and so they have a hard time charging that. But they're probably worth more. You see what I'm saying?
Yeah.
And I mean, public defenders are making what, $75 an hour for, like, not public defenders, but, you know, people coming in on public defender cases that are complex. Public court appointed work. I think they're paying like $75 an hour up to, you know, as far as the clerks go, what the clerks are paying out. You know, I think for felonies, it's like $450 or something. It's really nothing. So if we're going to try to set that up on the civil side, if it's not like a clean cut case where it's one court appearance and you're asking for multiple court appearances, like now the lawyer's starting to spend 3, 4, 6, 10 hours on a case that would generally in his regular practice maybe net $5,000. And I don't know what whatever that pathway is that y'all are talking about. I don't know what they're paying, but I think it's probably not that rate.
I think it's 500 a case,
Right.
which is high.
Just a flat rate.
But if you could stack, 4 or 5 cases that you're doing in a day, like that might not
Right.
be a bad thing. I mean, I hadn't planned to say anything. I just wanted to step
Oh,
in and
no,
say
I
we're hoping
appreciate
to
it. Yeah.
train some people up so that we're ready to help as much as we can.
Thank you.
Mary, I wanted to ask, do you keep any statistics on the number of calls you receive for help?
We do. So from the city's perspective, we are keeping track. I think also how many clicks to our website. I don't have an updated number for you right now, but it's over 1,000 calls per year. It's usually a couple hundred to 150 per month.
Yep. Okay.
And that's it. The issues range from I'm just looking for housing. Where do I rent? To my landlord is withholding my security deposit. To I see mold and they came and painted over it. It really runs the gamut, and it's much broader than the kind of cases I got when I was at LSNB. But again, the alternative is often, well, I can't give you legal advice, but this is how you file a tenant's assertion case. And here's some information to go and assist yourself in court. And people often don't do it because they just move.
I've got some
Come on up.
So, yeah. I'm Elizabeth Kriego. I'm with Legal Services of Northern Virginia. I used to work with Mary before she left us to do work for the city. But we, and I talked with a few of the attorneys in my office before coming here tonight, and just had some things that I wanted to pass
Sure.
along as the issues. And I agree with Mary. Like, is it work?
Work, WIRT.
Okay, work. Yeah, I saw you at the Bar Association meeting. I just haven't had a chance to actually introduce myself personally, but yeah, we are working with the Alexandria Bar Association to try to do eviction defense, pro bono stuff and really get that going. We would probably provide training for that and maybe kind of a framework for the ways that people can assist with those cases. You know, like maybe, you know, if this is the case, then these are the defenses that you could put forward and everything, to try and make it sort of a packaged thing that is more efficient. So because you know, it can be time intensive, especially if you don't know that area of the law. And if you are, you know, I was a solo practitioner at one point, and if I'm trying to make my living by charging clients, I can't necessarily afford to do things for free, you know, that take a lot of time. And so that's a big problem, is that a lot of attorneys out there they can't necessarily afford to do this stuff that is needed to be able to give people justice. I will say that there is a huge going to court and sitting through dockets. You know, I sit there and I can only represent the clients that I'm there that have come to me and are there to represent. I'm there to represent. But I will watch people in my same client situation get up time and again, and they have no idea what to do. And I go in there and I go up to the landlord's attorney and I say, "Hi, I'm in the case. Can we get this continued? Can we settle this?" And I'm telling you, 9 times out of 10, I can get that case dismissed. And so there's a huge difference between what the having an attorney in these cases versus not. Even if somebody has, you know, gotten behind on their rent or something like that, I can give them more time. I can look at the lease and say, there's some fees on here that are problematic. I can, you know, I have that credibility. And the judges, and unfortunately our system just doesn't see pro se people as credible as attorneys are. There's time that people are taking, especially when somebody is working per hour to try and do things. And let's say they're going to court on a debt or on an eviction for non-payment of rent or something like that. They're having to take time away from work, thus making less money to go to court to defend their cases. And again, you know, they don't have a lawyer that's there. Chances are they're not going to succeed in what they're doing. You know, and so there's a lot of issues with that. Some people choose not to go to court for that reason. And so you have those issues. Another issue is language access. That's a huge issue. It is not guaranteed in a civil case for somebody to have an interpreter in their case. You know, and a lot of times the judges are, you know, especially in like general district court and stuff like that, there's a lot of cases on the docket. They don't necessarily notice if somebody is struggling with the language because you're asking just a really quick question. And if somebody just sort of says yes, then they'll take that yes. They're not going to really delve into whether or not that person understands and needs an interpreter. Another issue that recently came up, and I don't do family law, but the family law attorneys in my office have brought up that you will have evidence in like a protective order case or an abuse case or something like that for a client that speaks another language, and their evidence is like a video that is in that other language. Court interpreters cannot interpret that on the spot, and the court has no way right now to do that ahead of time. And so you are seeing people that are bringing evidence to court in other languages, evidence that could be persuasive in their case and that goes to the heart of the matter, who are not being able to get that evidence in because it happens to be in another language.
So
Yeah.
it basically can't be introduced
Mhm.
at any point.
Yeah, I mean, it could be introduced, but there would be so many problems with
Yeah.
understanding what exactly it is and what it means.
That sounds like me, because I'm victim of domestic violence. I have a audio recording with my husband and what happened the night, and that conversation are in Mandarin Chinese. And I recorded that, but as a victim, I'm not there to listen to it. And I work with SMB, Ashley.
Great, she's great.
Thank you so much. Thank God I have her. And she's like the judge tells me that if I'm going to the court for a contact order, I need to have my proof translated. And I found every way to like figure out like who can help me with that. Eventually, I found like a freelancer online to help me to deal with that part. Like otherwise, I don't really know like who else can help me with that part.
Yeah.
I don't want to have my parents to like listen
No.
to what happened, or me. I'm not there to listen to the recording. It's really cool.
Yeah, and that it's great that she has the help of, an attorney from our office to try and figure that out. There are people that are trying to do protective orders pro se that don't have that support. Another thing is that, you translation and entering that as evidence can be a very complicated, nuanced sort of thing. You need to make sure that the interpretation, the translation is legit and is introduced in the right way. And so again, like you have some access to justice issues where if somebody is just not informed on how that works and everything, they could get it thrown out on a technicality. So, yeah, I think that's that. Again, we see all kinds of gaps in our office.
And
between
another
those
thing
things.
is-
Let me ask you to wait for 1 second. We'll
Yeah.
finish with
And could
Elizabeth.
she come up so we
Yeah.
can hear her?
Yeah, I think that'd be
Elizabeth,
great.
I do have a question for you though. As you sit and watch the cases progress with the pro se litigants, what are your observations about how the judges interact with them as opposed to the attorneys?
It's different, and I think, I have nothing but the highest respect for the judges in our court system. I think they're great people. A lot of times they're peers. We see them at the bar association
Mhm.
meetings and stuff like that. And I have great personal relations with them. But there is a sort of appearance of bias. I don't know if it's because, again, you're dealing with a situation where they have several different cases that they're dealing with, and if you don't come up and say the magic words, then it's too hard to go through it. Different judges have different ways of doing it. Some judges take the time to try and really help them out. Technically, you're not supposed to do that. Technically, according to the way our law is written, everybody is supposed to come at things with the same requirements, like the rules of evidence, the rules of civil procedure,
Right.
and stuff like that. And a judge isn't supposed to treat a pro se person different than an attorney. The problem, of course, is that a pro se person does not have nearly the same training that an attorney has. And we do not provide attorneys for civil cases.
Right.
And in civil cases, it is true that a civil case is not going to throw you in jail the way that a criminal case is, but it is going to have a large impact in your life if you don't prevail, or if you don't get it reduced or something like that.
I mean, we've obviously talked a lot. I mean, there's civil cases and then there's civil cases. It's one thing if you're suing for damages because the guy didn't repair your dishwasher correctly. It's another thing if you're about to be evicted or lose custody of your child or you have a protective order.
Well, a lot of times those things go hand in hand. We will see cascading effects. You lose your housing, you might lose custody of your children because you can't provide stable housing for them. You're fighting for custody of your children and therefore paying court costs for that. You can't afford to pay your housing, so you lose that. You get your car repossessed, you can't go to work, so therefore you lose your housing. I mean, like it all kind of just ties in and snowballs to the point where somebody is not able to have the life that they need to have. So,
Thank you. Would you like to come up? It's okay.
We
We could hear you better.
It's just, I received an email from Ashley, I thought she would be here and I came to. And then
Yeah, she wasn't able to come, but I'm here on her
Thank you
behalf.
so much. Thank you so much for bringing that back, because it was really talking for me for like, for 2 weeks, because I don't know what to do with that evidence, even I have one. And I know I cannot find one place for that group to help me out, and the court, actually thinking the transcript needs to be like notarized. And that's another problem, because what I found freelance or they're overbroad, and they're not be able to do that. That's really.
You should see me afterward. I have a Mandarin Chinese speaker who's in my office as a deputy clerk,
Okay.
who has done translation work. I'm sure that we can make that work.
Could you introduce yourself for
I'm sorry,
us?
I'm Greg Parks, I'm the clerk of the circuit court.
Would you like to say anything? We do have a clerk on the commission.
never likes to
Oh, I know.
Yeah, it was Paul Ferguson for
It's
a
not
few
me.
years. Yeah, no, your time may come.
Actually, I know the clerk on that very, very well. So yeah, I'm Greg Parks, I'm the clerk of the circuit court here. And from my perspective on access to justice, the 2 main things that I see, well, what we've heard before today, so absolutely so, language access. But one of the things that maybe the commission could do something about is that the ability of pro se people to access electronic filing.
Yeah.
I know that this current set of rules don't allow that, but that really cuts down. I mean, we have a high percentage of cases that are pro se. As Wirt mentioned, the legal price point in Alexandria is high. And so mostly you have attorneys who are doing it pro bono. And of course, is restricted. But the pro se, I mean, I think it's a double-edged sword in that the pro se people, if they can use the e-filing, in some ways helps them, because e-filing, if it's done right, has drop-down menus that, has, here's the kind of filing, here's the, the circuit courts are not form courts. So even my staff are trained so that they get a filing and they have to look at it and go, well, this isn't actually what you captioned it as. What you're trying to do is such and such. Now, we can't give legal advice. So, but, they try to help to the extent that they can. And the change recently to the rule about legal advice and where that line is very helpful in my opinion.
Good to hear. Thank you.
And, because my folks, obviously I need to protect my staff as well, and we can't be giving, unauthorized practice of law and all that. But my view of the e-filing would be that it's going to help people that are pro se, because you've got only a set number of drop-downs. Here's what the type of filing is, and maybe a pop-up that explains a little bit of what it is. Now, attorneys wouldn't need that, but it could help pro se people. Now, I know that's a heavy lift, but that's one thing that I think would certainly help. It would help my office staff enormously in getting things filed, obviously, just from a process standpoint. But I think it would also help pro se people in being able to get things in the way they need to.
So let me stop just for a
Yeah,
second.
absolutely.
One of the conversations that we had at a recent meeting of the commission was whether making e-filing more generally accessible would actually be, am I getting this right?
Yes, you are.
A negative, because
It just helps the plaintiffs.
the conglomerate landlords can just file more faster.
The only alternative I would say is it also would help with tracking though. It would make them file faster, but right now we're trying to scrape data offline. We could incorporate reporting as a part of that, so we would know exactly when they're filing, what the addresses are, because right now we're trying to scrape this data off of a form that's often handwritten or it's typed in, and the form reader is scraping, like, it just can't do it.
Yeah.
And so we are trying to, then we have to get someone to manually type the addresses out after getting the form from court. So I do see that one side of speeding it up, but it also could help us reach people faster.
Right,
Because
and-
right now we have no way to do it.
And the counter argument that we heard was they're pretty efficient anyway.
They're efficient.
Yeah,
I
they
mean,
are.
so it lowers their costs
Well, and I
incrementally,
do
that it
also-
won't make that much
I
difference.
do also think that the defendant side in that case, if you're a pro bono attorney and you can get that all e-filing and it's automatic and the notification goes out to both parties, I mean, you get that more efficiently. You don't have to spend as much time finding it, getting the filings.
Right.
I mean, I think it's much easier for, especially for solo practitioners to manage the pro bono case if that's what they're doing.
Right.
If it's e-filing.
Let me ask one other question.
Absolutely.
We have a lot of clerks of court in Virginia, and I don't
120.
think that you're required to use the same systems.
No, we are not. But the Supreme Court system, I think, is used by a majority of them. And,
Okay.
I mean, it is the one that is restricted. And in fact, I can tell you in Northern Virginia, because the 5 of us meet regularly,
Right.
and compare notes, because we have a bar. You know, Alexandria is not a huge enough market, basically, for legal talent that people who practice in Alexandria also practice
sure.
in Fairfax and in Arlington and in Loudoun, you know, et cetera. And so we try to coordinate to the extent that we can. And one of the main reasons that we are looking as the 5 clerks in Northern Virginia at using something other than the Supreme Court's e-filing system is because of the severity issue. And so, yes, I know there are a lot of clerks. There's 120 of us in the
Yeah.
state, or in the Commonwealth.
Thank you.
But, you know, ideally, having everybody on the same system would be the ideal outcome.
Right.
So the only other thing that really jumped to mind with me as far as it, and it's a resource issue, I understand it, is the reimbursement for court-appointed attorneys. You know,
Yeah.
and it's just, we pay that through my office, but, and I know it has been raised recently, but I certainly think in Alexandria, where you can, or you know, anybody who's practiced here can testify that it's just not enough. When especially the people who I see tend to want to do pro bono are the smaller firms or the sole practitioners, and they're the ones who are least able to stand a lot of overhead and without being
Right.
paid for it. So that those are probably the main things that I would see.
And one of the other initiatives that's percolating, and it's going to take a while because it involves the legislature, is trying to simplify and put forms into plain English. I don't know if anybody has any thoughts about that.
Well, I'm certainly in favor of that. That helps my office enormously.
Yeah.
Would your
That'll be
office hire
great for-
someone to do it? Would your office be interested in hiring someone to do it?
To simplify the forms, well,
You have to be a lawyer.
yeah, there's state level forms that are created by.
We've got a Supreme Court justice who's taken the initiative on that.
He's working on this, but it's
Justice McCullough is
it's-
working it personally.
it's a very slow process.
It's a slow process.
Yeah, no, I get that. And there's a lot of moving parts in that. It needs to capture all the information it needs to and all of that. I understand.
So David heard me say this earlier, and I'm sorry to interrupt with that, like I'm supposed to be listening and I'm going to talk. I've been working with a woman who had a name change 25 years ago, and there was a clerical error in the Fairfax County Court, and they put her birthday down as November 9th instead of November 10th. And she's a little worried about that in the current atmosphere. So I am not a litigator. I went with her down to the courthouse. We filled out the proper forms, did, with the help of the Fairfax Law Library, worked up the order, and I thought, no brainer. It's good. No, she needs to show up on motions day. Well, she works in DC, right? Is she going to go down there and file the yellow paper? Apparently you can do it online if you are the moving party, but I looked at these instructions last night. They are completely bewildering. I think there is a way to do it, but they are not. I practiced law 42 years. This is not easy to figure out. And I said to her, if it's hard for me and I take Latin, this is hard, So I kind of get like how a member of the quote general public, is going to have issues even when theoretically that is possible to be filed online. It's amazing how gnarly the system can be. But anyway, well, thank you for your work.
Yeah,
Appreciate it.
Thank you.
Anybody else want to come up?
Did you want to say anything else? You can also sit up here if you want.
Yeah.
Obviously, we're introducing you two, so.
Thank you so much. So nice to know about this.
It's okay. We're friends. I mean, we don't bite very hard.
Thank you so much.
Right?
It's just like been really overwhelming for me recently. I still have hearing on like just 30, and I really don't like. I'm still afraid. Like I haven't prepared for talking.
It's okay. It's okay.
Thank you.
Were you able to get a protective order?
Yes, I got the temporary protective order to May 23, and my first hearing was back to June 6, and on that day my husband did get a lawyer Amber has a LCD, and George said he would want to have both sides have a lawyer at least, so it moves for the justice. And the hearing moves to the 30.
Huh.
Yeah, but it's really like torturing me from beginning to the end, because like in the beginning I went to hearing justice center.
Right.
I checked out because I used this app called ChatGPT.
Right.
They bring me to there, and from there, the officer told me I can go to women's shelter for help, or they give me several numbers. I called, and the first number I reached is a EB program in Alexandria.
Right.
And it was Tanya. She gave me guidelines as like what you should do, and she suggests me in the beginning for a protective order back to May 10, but I was really hesitating because I don't know what that is, and I still like concerns my like husband, that's my daughter's father, and I didn't want him getting any criminal charge because I know that some like proof, and if I'm providing it, it might turn into a criminal charge. That's scary me.
Huh.
Yeah, and until like May 23, May 21, 22, my mother-in-law called the police and reported a missing child because I moved out back to May 12 with my baby. She was like 2 months old. And on that day, I feel like the detective keep calling me. And that's the first time in my life being called back police. It was crazy, scary, and like when the police called, my hand cannot like stop shaking. And
Sorry.
the third day, like Tanya, like I was talking to Tanya, says if I need to go to a court to evaluate protective order, and she like helped me out with that part, for family part. And it's still like taking me for like 2 days to finish that. For family and protective order
Yeah.
to the judge. Yeah, it's kind of really like overwhelming for especially like domestic violence survivors.
Well, we've heard about issues relating to protective orders in other hearings. And, one of the things that I think it's important for the judges to remember is that when you come before them for a protective order, you're in crisis. And the sense that we've gotten in other hearings is that frequently they're not as I'm not coming up with the right word, but they're not mindful.
Trauma informed.
That's the phrase,
Yeah.
trauma informed, that they are not focusing on the fact that there is so much emotion that can impede your ability to explain what happened. And it's and people are it's embarrassing.
It's very embarrassing.
It's very embarrassing, and then you have to relive it as you tell it.
I'm not there to tell any of my friends what I'm
I understand. I understand. I'm really sorry.
I'm really ashamed.
Oh,
No.
it's not you. It's not you. So thank you. And I'm really sorry.
But I'm so happy that everybody's helping.
There is so much community support in Alexandria, and even the prosecutor's office, they'll work with victim assistance. As you know, Ashley from LSMB is great, and the city DB program. So just keep calling if there's anything else you need.
Great.
Who else would like to speak?
Yeah, one more thing that I thought should come up.
Please, don't be shy.
This is very, very prosaic after that, but
it has come to my attention that it may be, and I don't know this personally, but that it's unclear as to the usability of electronic signatures. And I know that some judges say that they're not, and that they were only admissible during the state of emergency that would happen during COVID, and in other courts and other judges say they are admissible. From an access to justice standpoint, being able to take a signature that was signed electronically is a huge bonus. So I would think if it is possible to clarify that so that it's the same rules statewide, so that some judges can't say, yes, you can do that, some say you can't do that, because it gets, it's confusing for my office to administer. It's also, like I said, electronic signatures. I know there's an e-signature act in Virginia, but we still have trouble sometimes.
So
you have to get an ink signature.
This is very interesting because David and I just got an email from a circuit court judge in Culpeper that he is doing a program through the state bar, I think on July 25th, on electronic signatures, which I will forward to you.
Excellent.
And it's going to be streamed.
All of the judges.
It's going to be streamed. But so my day job when I worked was dealing with mortgages. And of course, during COVID, almost every state changed their notarization rules. But the validity of electronic signatures is not a county by county thing. I mean, it's a statewide thing. And Virginia, I think, has enacted both UEDA and UCEDA. I mean, these should be.
Well, maybe there's an education opportunity.
Well, I'm saying there's a different
for
committee of the Access to Justice Commission that works on judicial education and trying to get things into the bench books and this, that, and the other. And that's something we can certainly bring to their attention. For that's really kind of helpful things. Good.
Mary's friend. What brought you here?
Well, I was just interested. I'm Ellen Digg, and I'm an attorney in Alexandria. A lot of the folks here, and I wear a number of different hats. And so I had sort of previously, when Judge Clark was doing an equal access to justice at 520 King Street, you may have participated in that too. And so when I saw the announcement for today's session, I thought, oh, this is a loop that I should probably, check out, because I do. I wear a lot of different hats, and almost all of it is for the indigent population in English and in Spanish. And so, equal access to justice on every level is something that I'm daily working with my clients on. And as a practitioner, very frustrated about a number of things that make it almost impossible for attorneys to earn a living. And when I say earn a living, I'm not talking about earning a living so we can drive a Bentley. I'm talking about earning a living to pay our malpractice insurance.
So can you think of like top 3 frustrating things? 5?
Sure. So in terms of practitioner, I'm very grateful that there was a slight increase in pay.
Okay.
For court-appointed attorneys and guardian ad litem attorneys. So guardian ad litem attorneys can be both adult incapacitated persons, which is different than sort of, what is it? The cohort that is, for example, Mr. Park's office handles, which is a different level. But there are incapacitated and vulnerable adults that are entering the juvenile and domestic relations system, right? And so, we got this slight increase, not on guardian ad litem fees. I don't think ever changed. Maybe the last change was in the 80s, maybe the 90s, as long as I've been doing it. So I know this is what, everyone's very aware, and I just want to, go on the record of saying those couple of extra dollars, especially on the child welfare cases, sure, it helps a little bit. But I think that what I would like the commission to consider is that let's take a juvenile delinquency case. So that rate is $90, per hour, right? With a cap.
Yeah.
Right. And the cap's gone up a little bit. Like if there's a little bit more that we can claim. But let's go back to, let's just start it at $90. Okay. So I take a juvenile delinquency case for $90 per hour with a cap, let's say the new fee is let's say $360 or something like that. All right. So whatever it is. And I have to go to court 4, 5, 6 times, right? Okay, well, fine. So you do what someone else suggests. You try to stack it up, try to get in there on the same day over dockets that we have no control over, right? But the big problem is that $90 under the, an hour kind of lens. Well, if I'm going to court 4, 5, 6 times on a case, that means in Northern Virginia, I'm paying for parking. So that $90 is less $10 for whatever parking garage you're in. Sometimes it's $15 for every parking garage. So we're not allowed to claim parking for any court appearances, right? So if I'm going to court, I'm actually not low bono, I'm in the hole, right? And the other thing that I would say is that is super important. And I'm sure the folks in Richmond who think about these things, have a lot of different sides of the kind of the ball, the lens, it's kind of like a disco ball. Every time you talk about it, light is shining off in a different direction with a lot of different issues and demands on resources. But we as indigent representation, and thank goodness for LSNV, thank goodness for our folks at Legal Services and the attorneys that I've worked with forever who are, just fearless, relentless, and always available to help anybody, whether it's a colleague or it's their client. But we're fronting all of this. We are subsidizing and using our personal money often, or our spouse's money, to front these litigations. And we're doing it every single day. Every single day that I step into a courtroom, I am subsidizing, number one, the person that I'm representing. And number two, I'm giving a loan to the Commonwealth of Virginia. And with the hope that a judge will sign a voucher, with the hope that a judge will sign a voucher within a couple of days, with the hope that OES will accept that voucher and not reject it. And it's a major problem in circuit court, where a judge under 16.1266F appoints, makes a finding that a child or vulnerable person, a vulnerable adult, whose interests cannot be served except by the appointment of a guardian ad litem, and to be notified by a clerk of court that we are appointed to a case. Most recently, I got a call, at 7:30 at night when folks came out of court. An attorney said, "This judge has put you on a case." Wonderful, happy to do it. And I'm already on the clock working. I've taken the call. I'm working. I'm setting up a file. I don't have an order. I don't have an order, but I am professionally bound. If a clerk calls, and says, you've been appointed to a case. You've been appointed to a case. And so we're fronting this money. We're investing our, for me, it's sometimes not just the legal work, but it's legal work in another language,
Mhm.
right? And I'm, vouchers get processed. I have a judge that approves a voucher, especially in the circuit court, and it gets rejected. And the rejection normally is there is no authority to pay out of the criminal fund for this case. And so 4 months, 5 months, 6 months, a year later, if you're guardian ad litem at $55 gross, if you even get into court, it's $75 minus everything. I have personally, and it's not me, it's my husband. Well, I mean, it's only funny until he, would like to retire for the third time, right? It's only a chuckle, except if you're him and has to get up and go to work to keep the lights on, and it's exhausting. And to the judges want it, well, the majority of judges honor their orders, and the majority of judges pay their vouchers. Maybe it takes them a while. I get it. I get it why it's slow. The electronic voucher system is amazing. It is the best thing, Virginia, I've ever seen. The best package, best software that I have ever seen. A couple little tweaks to it, but when they did it right with that EVPS system. It is phenomenal. It is almost impossible to submit an indigent voucher and it not be accepted. And I tell that to OES all the time whenever I have to call down there and say, hey, what about this? What about that? So the software is phenomenal, and I so appreciate that. And I think the folks that are made that decision really need to be lauded for that. But if, just because it can finally land at the right desk down there, if they don't have the authority to pay, they don't have the authority to pay. So that is a major problem. So what do I do? Like, what do I do? Because remember, if you are serving as a court-appointed or a court-appointed guardian ad litem, you cannot claim pro bono hours if you are appointed. So if I'm working and I'm in the hole on a case by $5,000 or $6,000, and I'm under the old fee structure, maybe I'm going to get paid $120. I can't even claim that it's a pro bono. And then, so 2 more areas, and then I'll stop.
Okay,
So other folks would like to.
I'm learning.
So.
Well, and I'll say what you do there. A lot of people just take themselves off the court appointed list.
Right.
And lose so many good attorneys that way. And
Or
don't-
they're removed from the court appointed list. Absolutely, I agree.
Right.
100%. 100%. The other thing that I think that the commission needs to be super aware of, and if there's a crisis of attorneys now, it's going to get worse, and it's coming. The train has left the station on this one. We have many jurisdictions, and all of the jurisdictions up here use the, we've got a digital discovery in criminal cases. I'm sure you've fielded some issues on that.
We tend to focus on civil as opposed to criminal side. There's the other side of the house.
So I won't get into the real issue, but I will tell you.
Raise anything you want to.
If there is a
Our ears are open.
crisis, of court-appointed attorneys, it is going to get worse because we can't get paid for what, it's raw footage, and it takes sometimes scores of hours to review electronic because of body cam imaging, et cetera. You used to go to the prosecutors, you'd sit down, they'd hand you their file, you'd leaf through it, you'd make your notes, you'd make your copies, you'd put your requests in, and it varied a lot, from Commonwealth's attorney to Commonwealth's attorney. I mean, Alexandria and has always been incredibly open and kind about discovery even before we went to the electronic. So, there's a cap. There's a cap on what
Is
we
this
can.
body cam?
All of
footage
it,
review?
all of it, all of it. Body cam is raw footage. You have 5 officers that show up and they're on scene for 5 hours. Well, you're right.
Yeah.
And so, and we're not getting paid to do that. And what's happening in terms of access to justice, that means that those indigent clients are not getting to see the evidence. So it's a due process issue. So you have that issue going on. So if there's going to be a further flight off the list, what's going to happen is an attorney is going to get dinged, a really good attorney that works hard is going to, and will be very hard, lose an effective assistance of counsel because there is not enough time. And then you have to go in, not only do you have to do it all, then you have to go into a facility and review it all with your client. Well, it's just not possible. I'm very grateful for the electronic discovery systems. I mean, it's great in the one hand, but in the other hand, how do I do that? How do I dedicate what I need to do on the criminal or delinquency side and keep up with all of the indigent civil litigation that I also want to keep up on? And then I guess you said top 5. I think this is my number 4. But so I don't know if this group considers when forms don't track with the statute.
Should.
Yeah.
We're interested in forms.
Yeah.
Okay. So there is a DC, the DC 540 form, which is the standard guardian ad litem order of appointment that lists the code sections 16.1 to 66 and the other, and that may be the only code section that's up on that form. Oh, I could probably pull 5 of them out of my bag. But at any rate, that it's a 2-page form front and back, right? And that form is the form that is used to appoint a guardian ad litem for a child that by statute is incapacitated. Might be competent, but they're incapacitated. Or number 2, for an adult incapacitated person. The problem with the form is on page 2 of the form, if you go down to the last paragraph of that form, that paragraph says, hey, third party, when the guardian ad litem shows up to present this form, they have access to whatever they need, right? It's in lieu of a subpoena or subpoena or anything. This is the Willy Wonka golden ticket, okay? That form the front page allows any judge to check the box, adult incapacitated or adult mental health or other, which comes under 266F, right? But when you go to a third party with that form, and for me, 99.9% of the time it's in a civil case, if I'm appointed to an incapacitated adult who's nonverbal and is in a litigation, and I present this form to third party, that form, page 2, final paragraph, says the guardian ad litem gets access to anything related to the child. The form does not say the guardian ad litem gets access to anything related to the to the subject. And so it's a really, really big problem for guardian ad litems who are, in the moment appointed to represent a vulnerable adult. And we can, so if I am a guardian ad litem for 2 people, and one is a child and one is a vulnerable adult, the vulnerable adult does not have adequate representation because they can't sign releases, because they can't, they're incompetent or whatever,
right.
they're incompetent or incapacitated, right? Whatever it is, And that is the same as a child. I mean, an incapacitated adult is the same as a child. They're unable to make decisions. And so it would be really helpful
To change
if the form would track the statute so that we could, number one, be able to effectively represent our children. And these are different than adult circuit petitions for guardianships and conservatorships. That's a whole different silo, and I don't want to mix apples with oranges. How that is done, it's different code sections, it's under different titles of the code. I'm talking about
Okay.
the welfare cases, the delinquency cases, the victims, if they're a victim of a crime, right, under 19.2.1101, a victim of a crime has the right to be informed and participate at every stage of a criminal proceeding. And if they're incapacitated, and a victim, if they're, they need their attorney, guardian ad litem, to be able to advocate for them, right? 100%, and participate in the proceedings and to be able to have access to the same information as an incapacitated. So it is a major access issue for the very people that are trying to represent the most vulnerable people in our community. We as practitioners are incredibly vulnerable, and there's no one to talk to about it. There's nobody. We can, call Mary, call anybody and say, what have you guys done? And, they'll go, yeah, we had that issue once or twice, or, let me give you some advice. That's time out of their day, but there's no advocate. There's no help. And and so what's happening is these people who need the help the most, access is really, really denied, and we're doing it at a huge risk. And that's why it's getting smaller and smaller and smaller. The lists are getting smaller, the people willing to do it are getting smaller. What's happening in different courts is making it impossible. So there you go, you asked.
Ellen, the first hearing that we did in Warsaw, Virginia, which frankly, I grew up in the state Commonwealth, and I had never heard of Warsaw, Virginia, but it's like a suburb of Tappahannock. Right? I mean, it's like, but there's a prison there. So I said, I thought the population was like 2,000, but it turns out half of them are incarcerated. But one of the things that we heard there was, and almost in every hearing has been about the problems with guardians ad litem, and how, there are states now where you need training, but you don't necessarily need to be an attorney. In Virginia, you do need to be an attorney. The pay is really terrible. But in Warsaw, in order to be divorced from someone who's incarcerated, the incarcerated individual needs a guardian ad litem.
Of course, it's by
I mean,
statute.
you can't, right,
It's by
right.
statute.
But think about it, in Warsaw, like, you think there are problems here? And, in Richmond County, Virginia, it's almost impossible.
Well, I
mean,
would say
it's-
that's an interesting point, and I would just say this in case this has come up again, because I have felt for a very long time that the guardian ad litem program is on its way out, and it's going to model some of these other very unsuccessful jurisdictions, other foreign jurisdictions that do not appoint attorneys. The guardian ad litem is the only person in a litigation who is subject to sanctions if they don't perform their job. And so if the wind is blowing that way, or if it's gusting more, which is what I think it probably is that if this Commonwealth cares about vulnerable people, then those vulnerable people should be represented by individuals who are subject to sanctions if they do not do what they are supposed to do and perform the way they're supposed to perform. You cannot say on the one hand that we really care about vulnerable people, and we really care about children, and we really care about child welfare, and we really care about people being evicted, and all of these things unless there is going to be a commitment to ensuring that you don't have lay people wandering in who are not held to some standard, because these vulnerable people are incapacitated. They cannot cure their incapacity.
So let me make sure that I understand. What you're saying is the guardians ad litem can be sanctioned.
Right.
And who are the people who can't be sanctioned? The lawyers or others?
Non-lawyers.
Other states.
In other states.
Oh, in other states.
In foreign
Oh, in other
jurisdictions that
states.
use non-lawyers.
So you would not be in favor of non-lawyer GALs?
It's not a guardian ad litem.
Okay.
It's not a guardian ad litem, it's something else. But
I
this
see what you're
it's
saying.
litigation. I mean, why wouldn't you have the most vulnerable person in the proceeding be an attorney? I mean, if the state is going to be represented, if the locality is going to be represented, if the landlord is going to be represented, if the parents whose constitutional rights are going to be represented, then why would the most vulnerable person that you're trying to protect not be represented by competent counsel? Why doesn't it matter? Like, and so, I'm very, very concerned about that. I've been concerned about it for a long time. And if that's where it's going to go, then do it or pay us.
Interesting. I think that there is a group. I think there is a group in the court that's looking at the whole GAL system, but I don't know enough about
I've
it.
been doing this for a very long time, and I have not been asked to participate. I don't know any of my colleagues that have been asked to participate in any group that's looking at, the efficacy and validity and budget-wise decisions about the guardian ad litem program. I haven't been. I haven't received anything about that, and I don't know any colleague who has.
So among the lawyers here, so as I mentioned in the beginning, David is still involved with this state bar group that's looking at legal deserts and the diminishing number of young attorneys who are coming into the Commonwealth anywhere, not just in rural areas. Are anybody here experiencing issues with hiring, retaining, and so on, new lawyers?
Yes. I mean, it's LSNB is always, there's always, I don't know if we have, it comes and goes, but I do know that we often have positions that stay open for quite a while. And I mean, we don't pay as much as other law firms pay, but I mean, again, we also.
It's just it's so expensive to live up here.
Yeah.
When I first came out of law school, I was living in Roanoke,
Right.
and I bought my house for $250,000, and I think that would.
Oh, you can't do that
very
here,
much.
Yeah.
And we moved up here after 10 years of practice, and we were renting and couldn't afford to live here until I hit a huge rent out case. I mean, it's just the way it goes, unfortunately.
I have clients, indigent have a higher standard of living than I do. It is solvable. I mean, there are ways to entice attorneys to do this work and make these commitments so that they can then sort of expand, reduce their indigent practice, right? But still be really, a knowledgeable source and kind of hand it off. One thing that I've never understood, and certainly I would have done, given this a lot of thought, but we have court-appointed attorneys, guardian ad litems, et cetera. We have the only thing, unless we have some other revenue source, right? The ones that do it primarily are, the reality is you're looking down the barrel of a Social Security pay, Social Security when you become of age. There's no retirement. There's no savings. There's no tax benefit. there's absolutely nothing. And so, for myself and a number of us who've been all doing this for a long time, unless we have some inheritance or a spouse that's, willing and doesn't become so ill that they have to go into assisted living, for any of us who are approaching these ages, or, how is the attorney going to live after giving their career for 20 or 30 years because the community has asked, because the judges have asked, because they say we need you, and we're grateful, the ones that do, and most of them do. But then what? Well, how am I going to live in another 10 years? How?
But be well,
And
Wellness is
but we have to
important.
be.
Yeah, right.
and I'm just saying-
We're very interested in wellness for the
Yeah,
last
there's no
Right.
dozen
interest-
years, yeah.
There's no interest in wellness,
Yeah.
it's baloney, and I'll put it on the record, stream it wherever you want. But, we get no tax incentive. I mean, you work for 10 years, can't at least the student loans be forgiven? Can't we work towards, if we're willing to commit for 10 years or 15 years on a graduated scale, 20 years, if you're willing to toil at legal services, so if my student law school loans exceed what my Social Security payment is going to be,
That's not a good look, is it?
but it is the look.
Yeah.
But it is the look for many, 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 many of us. So they jump ship and go do other things where they can work for a few years and maybe get a couple bucks into, the Virginia system or whatever it might be available to them. And I don't understand what we're doing. So if the Guardian ad litem program that's where it's going, and they're taking a look at dismantling it and making it something else, I'm very sad, but it's certainly, the lights have been on the track and you hear the rumble coming.
So there is some movement to revamp the GAL system?
Well, I can't speak to that. No one's asked me to participate in anything like that. But I believe that it is a very vulnerable part of the legal field for the welfare, because there's no money made off of impoverished children and welfare kids. There's no good optic for it.
To just kind of add on to that, when I graduated from law school, I wanted to be a GAL. I went to law school and studied family law. That's what I concentrated on. And in Richmond, I would go around with guardian ad litems and learn. And then I moved up here and wanted to get into it. And it was a financial impossibility.
Impossible.
I was told you have to go to a large scale law firm that will let you do that on the side. Otherwise, I couldn't afford to do that as a young lawyer. So just thinking about the pipeline, there's no, whether you're farther along in your career or you're newer in your career, it's almost impossible at this point to become a guardian ad litem unless you have a second
source of
income.
Yeah.
income.
And so it became an impossibility. I could not do it.
So appointed attorneys are really subsidizing our judicial system.
A guardian ad litem,
Yeah.
and not just, it is being done. It's not a, wow, that's kind of a random thing to say. So this week, I am appointed to, let's say, 4 new cases, maybe more than that this week, right? Boom, 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 boom. All a welfare or delinquency case, just this week. Well, today's Tuesday. What's today? Today's Tuesday. I say last week.
Last week,
We work
right.
all the days. We work
Right,
all the
right.
days,
Yeah,
and
yeah.
there's no weekend, and we're working all the days. So within the last 7 days, let's say I was appointed to 4 new cases, which is probably just me in these civil cases. So there's 4, 5, 6 attorneys involved in some of them. So I'm one attorney of a whole, cohort. That was the word, cohort of attorneys that are all getting the same calls or the same notice from the clerk, right? So if it's a removal case or a child protective order case for abuse and neglect, I'm not going to get paid probably for 6 months. So all of that litigation, the copies, the mileage, the file folders, the time, the interviews, the parking fees, all of it. And the copies, I left them in my car, so it's too hot to carry my bag full of stuff. You know, I have files that I've been working on for a week and a half that are already this big. So all of that paper is, I've advanced the Commonwealth of Virginia. And these are heavy paper cases, right?
So this is, I mean, what you're saying resonates. We hear it slightly differently, like in the two counties in the Eastern Shore. They don't pay a lot for parking, but, you know, the courthouses are 45 minutes apart and they have to appear in two different courts, you know, at two different times. And the judges seem to be fairly adept at juggling things to try to make that work because of the, you know, paucity of attorneys in that area. But I mean, it's a different but analogous problem in the more rural areas.
Oh, I would say that the rural areas, that the urban areas, at least in the courts that I practice in, now resemble the rural areas. It is the same dearth.
Yeah.
Well, that's one of the things that actually occurred in my office and other clerks' offices during COVID is anything that can be done to facilitate remote hearings and remote appearances, I think is a huge plus for access to justice. I mean, during COVID, you know, we, and I still interpret the statute that says you have to appear before a clerk, doesn't say you have to appear in person. And so I think that is satisfied by appearing on video. And, you know, so to issue a concealed carry permit or a marriage license or things like that. But that is something that is a huge time saver. Attorneys don't have to make the trip to the courthouse. The parties don't have to make the trip to the courthouse. The other thing about the compensation is it's not just lawyers. That is the biggest problem. But my office, the state compensation board that funds the constitutional offices does not do locality adjustments. So a deputy clerk that is hired in Warsaw or wherever you were, pays the same exact amount as a deputy clerk that is hired in Alexandria. And the cost of living here is 7 times or more some of the rural areas. I know because I looked it up. And so there is no locality adjustment. You know, in the federal government, if you're a GS-15 in Omaha, Nebraska, you make $25,000 or $30,000 less than a GS-15 in Washington, D.C.
Right.
Because the federal government does locality adjustment. Commonwealth of Virginia does not, at least for the constitutional officers. And so what that ends up doing is that forces the localities to supplement the state salary. Like for my office, I could not keep or hire a single deputy clerk on the salary that the state compensation board pays the people. I mean, $34,000. I can't hire somebody.
And what happens is Mr. Parks trains these people because his people are amazing, and they're amazing, and then they go over to the federal government.
Yeah,
I mean,
they
stay
find
for
a
2 or
higher
3 years.
Yeah, no, it really, it's a huge problem. And, you know, that locality, I understand that's a cost issue for the state, but we really have a hard time. You know, and it forces all of that expense onto like the city of Alexandria.
Right.
And, you know, the other, in Northern Virginia, all of the localities supplement the clerk's office salaries to one degree or another. More so now, data center money is making Loudoun County and Prince William County able to compete wildly because they have lots of money. Arlington, Alexandria, and Fairfax, not so much because we don't have data centers. So, you know, unfortunately, Alan's right. I train somebody and, you know, they may go even to another clerk's office because their locality supplement is higher. It forces all of the clerk's offices, I know this happens in the Commonwealth Attorney's offices and the sheriff's and the other constitutional offices. It forces us to be competing with one another when we shouldn't be. You know, and so that's just a real issue. And I don't know how we get there, but locality pay would be a huge start on being able to attract and retain good staff.
And I can attest to that too. And I worked with Greg when I was in the city manager's office, just trying to advocate for some equity and fairness. You know, for instance, when you talk about body-worn cameras and all the footage, you know, the Commonwealth Attorney's office would get more resources, but then the public defender, she was up at night till midnight and couldn't get a paralegal because it wasn't in the budget.
Right.
So it's that kind of thing that I think the Commonwealth needs to be aware of as the laws change. Greg's absolutely right. There needs to be an acknowledgement of just the reality in the various jurisdictions.
Well, Northern Virginia drives a huge percentage of the Commonwealth's tax base. So, for us to then be told, oh no, you only get $34,000 for a deputy clerk, I can't hire somebody. That may be a great salary in some places, but I can't hire somebody.
Court-appointed attorneys, guardians ad litem, public defenders, Commonwealth's attorneys, clerks. It's not about the money.
Right.
It's not. I mean, we wouldn't do it. I mean, anyone who's an attorney, has made a deliberate choice to serve the community, has made a deliberate choice, and I would challenge anybody, whether they're in Richmond and wearing a robe, or they're here, or they're, at city council or whatever, I would challenge anyone to find a more difficult and important area than child welfare and family court. It is where the rubber meets the road. It is the human behavior, and it has the most lethal outcomes. And we've got these clerks that are working to try to get, every day into the state system, the protective order information, the gun restriction information, and they're worrying about going home, picking their kid up, dropping the kid off at grandma, and then going to their second or third job, right? Mm-hmm. Whether anyone wants to talk about it or not. I mean, they're supplementing, maybe they're driving Uber, but they're supplementing that. That's the reality. And they make a mistake and somebody gets hurt. Mm-hmm. Right? And they make a mistake and something doesn't get input right, and a police officer shows up. I do a lot of mental health work, and that's another conversation about that, vulnerable people. But it's time to, can't we be done talking about what a shame it is?
Yeah.
Like, can't we be done talking about what a shame it is? Because all of the people, I would think, that are on the commission and working, I don't know who they are, but if they have a pension,
they all have pensions.
then
Yes. Right.
Then you're not speaking our language. Then you're not living in our reality. And to continue this way, to live in this, in this fantastical world of we're trying and we're invested and we gave them a little bump up in money, but and this, that, and the other, it is a complete decision to be detached from reality. And this fantastical thinking and what's happening and how these attorneys, it's not just me. I can step out and stop working and whatever, but there's a whole other bunch of cadre of attorneys that are being very terribly used and abused for nothing, it's not about making good money so we can get a bigger car. And this sort of like, why can't people get help with landlord tenant stuff? Like it's not difficult.
You would just change the law so if the tenant loses, then they pay the landlord's legal fees? Didn't they just make that up?
Well, I know.
No, they always have to.
It was always.
That's always in the leases.
So if we have, at a bar function, several months ago, Marty was saying, UVA had 17 law school graduates take the Virginia bar.
Wait, only 17?
That was last year.
Last year's number.
Wow.
This year it's up to 25 or something.
Right.
250 students.
Out of
No,
it's
300.
300.
From Virginia's
Yeah.
best law school.
Yeah.
Wow.
That's an admissions problem.
We
Well, no, because they take the bar someplace else.
Yeah.
The class size.
Yeah, no, I mean, yeah, that's,
They're elected.
but they're deciding
To go
not to
somewhere
practice
else,
in
yeah.
Virginia.
But in fairness, because I graduated 45 years ago, I think even then it was well under 50% because people go to DC and take the DC bar and whatever. And what's interesting is if you look at 10 years after graduation, there's a large percent of UVA law grads who are practicing in Virginia. They've been admitted on motion or gone in-house or whatever. But that's for a different day.
Business suits for the bar exam?
Well,
That's no longer a requirement.
That's the way it
Is
is.
that
Really?
not a
Yeah.
requirement anymore?
Nobody knows it. Nobody knows it. One of the bar examiners told me that.
Wow.
Yeah.
Bar, when I was on bar council,
They
there was a
have
vote
something
on that,
like
and,
that.
and they all voted that you had to continue to wear suits. It's like, really?
Yeah.
That was pretty shocking.
May I just build on
Please.
what was suggested with actually having training materials for pro bono attorneys?
Yeah.
I have always thought, as a former pro bono person and LSND person, that the state bar and the Supreme Court should come up with training materials in working with the bar, the various bar associations. Have those available. Obviously, the laws are the same throughout, in all of the circuits throughout the Commonwealth. And then have the local bar associations responsible for kiosks or part-time librarian who helps, or Greg, or whoever, take Greg more. But just have the localities and the local bar associations work in concert with the Virginia State Bar and the Virginia Supreme Court, so that we have a more uniform system of assistance for pro se litigants to start with, and then quality materials. So, because at LSNV, we would have training at Virginia Poverty Law Center. I mean, we have great training, but that didn't translate into sharing it with a lot of other people because we didn't have time to train everybody. But I think there's a way that that could be done in a cost-effective manner. And then I've been thinking while I've been sitting here, I honestly wanted just to observe, but I'm the former director of the Human Rights Office in Alexandria, relatively newly retired. And so Andrea knows that I'm getting involved with senior lawyers in the Commonwealth. And I think there's a lot of talent and time and energy that we could take advantage of. And so if we had these training materials, if we had this system of excellence and uniformity, I think that's sort of an untapped resource. And I know that one of the committee members was actually suggesting that we have a Zoom call soon to talk about that.
For what it's worth in Alexandria, ideally, after October, we will have a bank of CLEs that people can sign up and take these things to get pro bono training,
Right.
at least as long as they're a member of the Alexandria Bar Association.
Right. For the
And then we
locality.
can start,
Cool.
you know,
And
filling that
you know,
whole year.
I completely endorse that.
But the
Ideally.
reason we have to do that is because there is no state level
Right.
can training to the extent, and you know, thinking of even, we can continue to pull that thread, right? The training that we would need for lawyers is one kind of training, and then there's a training you would want to have available that's canned for the public.
For the
So they
Right.
can teach themselves,
Right.
because you know, we keep putting more and more like, just give them a lawyer.
What I'm
There's not enough of us.
Right.
And so like, that they need to be two
It's-
different.
Don't other states do that? Don't other states do that?
Yeah, with varying degrees of.
I know DC's not a state, but they certainly have bank.
Yeah.
Pro bono material.
Oh, yeah.
No, yeah, we have to vote on materials. They're not, like you mentioned, Marty from.
Yeah.
There's a lot of things that VPLC, Virginia Poverty Law Center, has created a lot of really great materials. They don't cover every single subject matter, and sometimes it is very hard to boil down legalese into plain English, like, you know, we've talked about the forms and stuff like that. I think the materials, you know, and it takes an effort. It takes, who's in charge of updating those materials?
Absolutely.
You know, like housing law, for example, changes like every year.
Yeah.
There's always something new that's happening, and who's responsible for making sure that those are updated all the time?
Well, Jean is aware, the Senior Lawyers Conference of the State Bar, which is about to be a section, and apparently everybody over either 50 or 55 is a member, theoretically every 2 years puts out something called the Senior Virginians Legal Handbook.
Yeah.
It was 3
Yeah.
years. It was, but it's being reprinted, like, it's gonna be paid for
Is it
before the
gonna be
30th.
printed?
Yes,
Because we
no,
had to-
it is gonna be printed. It is gonna be printed, but
There's a thing- we
updating
had to
it,
give out QR
like,
codes. It seems a lot.
updating it takes, it's a huge amount of work. I mean, and that actually would be, I don't know how helpful it would be for pro se litigants. It's very interesting in editing it, trying to get enough information in so that people are informed without going too deep
Right.
where they tune out. You know, there's this sweet spot of enough information to like allow them to issue spot without going too far into the weeds. But that is, you know, sometimes a helpful resource. But it's true. The updating, it's got to be maintained or it's potentially dangerous.
Right,
you know.
you'll get somebody that's doing something and it's completely outdated, so it helps them not at all.
Hang on, I think the pizza's here. You'll excuse me for not. I'll be right back. You'll excuse me, Greg, when you were talking, my husband was saying, it's gonna be 45 minutes. So that was what that was. I'll be right back.
We had plenty to talk about.
Are there any topics that we haven't raised that we should?
David, I just want to mention one other thing that I thought of. It's Jean Kelleher, from the human rights and civil rights perspective. A person in the Commonwealth of Virginia does not necessarily have equal rights with someone in a different part of the Commonwealth. So by way of explanation, Northern Virginia, Tidewater, we have local human rights offices and commissions. We have a couple of human rights commissioners here. And I'll just focus on employment because that's primarily what we hear about and what we would do is employment discrimination cases. And as you know, there could be federal jurisdiction, concurrent federal and local jurisdiction, or maybe just Commonwealth of Virginia jurisdiction. And often individuals don't know what triggers jurisdiction based on the number of employees, for instance. But what I want to point out in Virginia now is because the state office, the state human rights office is within the AG's office, the Attorney General's office. It's the Division of Human Rights within the Attorney General's office. It has become totally political. So the type of representation one gets depends on who's in the governor's office, and that I'll leave it at that. There have been many fewer cases brought in the most recent administration than we, even in Alexandria or in Fairfax or Arlington, would bring in a typical year or 2 year period. The other issue that's happening is if there is concurrent federal jurisdiction, then of course the EEOC, the Equal Employment Opportunity Commission, or these local offices or the state division can handle it. Typically, if you're not in a jurisdiction that has a local office or a local commission, then the EEOC will send that case to Charlotte, where it's typically summarily dismissed. So what I'm saying is that in some jurisdictions in Virginia, because we have local offices, we get to know the attorneys, we get to know the employment bar. There is no case that's too small to take, to litigate, to settle at the administrative level. We do that all the time. We try to let individuals know they don't need to hire a lawyer at that particular point when they first file a complaint. But eventually they might need to get a lawyer, in which case a lawyer would be able to get legal fees and so the person would be made whole. But I just think that it should be reported that there's very disparate treatment of discrimination cases that are brought in the Commonwealth of Virginia.
Very much. I've had personal experience occasionally with people who are looking for plaintiffs' employment lawyers. There are none west of Richmond. There's one firm in Richmond that does plaintiffs' employment law, and I don't know about Tidewater or Northern Virginia, but it's very.
We do have some excellent attorneys, and we work really well with them. And we, at the administrative level, I still say we. I'll say we till I die. We work closely and handle the administrative level, and then if it gets to the point where we say you probably should talk to an attorney, he has a list, then we go from there.
Right.
Because if there was consistency, I think with the technology, so if I walk into court in JDR court, or General District Court in Falls Church, or Arlington, or Fairfax, or anywhere, boom, screens up, mic'd in, you're ready to go, right? So where there are jurisdictions where they're not bringing, the type of employment cases, there may be attorneys here that would appear in Wise County if they could be up and on the monitor. And it's the same for child welfare cases. Do you want social workers sitting around court for 7 hours? Or do you want them to be able to continue to do the work so that the jurisdiction can get their Title 40 funding by getting the paperwork done in the right way so they can get reimbursed by the federal government, right? Instead of sitting on a bench where they can't bring in electronics and obviously can't do confidential work. But if you have an attorney that is from here, that is kind of knows a lot of stuff and could appear, it should be uniform. If you can appear virtually in one court, you should be able to appear virtually in all of them. And I can tell you what a terrible issue it is with the mental health docket, and it's now all virtual, everywhere, and why don't we have technology, and why is it so difficult, even though it's better for the patients? I have an attorney this is on my docket who is now in New York. But because of the virtual platform, he can physically be in New York, but he's, our Virginia attorney who's willing to do those types of hearings a couple of days a month. But the sound quality should be the same. Tying in language lines should be the same. There shouldn't be police officers carrying around iPads, trying to, go into an emergency room and prop up the iPad on the dinner tray to try to make sure that the patient can see and hear their court proceeding. And so, you walk into court in Arlington, I need a link, boom, the link is up, it's done, and, there are multiple screens in a courtroom, and everybody's there, and the proceeding moves forward. Many times they don't move forward, but it's not because of technology.
Yeah.
It's not because an attorney is caught in Fairfax and can't get over to Arlington quick enough because boom, they're up. They step out of whatever they're doing. They step into the hallway. I'm waiting for another case to be called, and they're in.
It's ironic that the courts in Northern Virginia, which tend to have, of course, more attorneys, are so technologically forward. South side and Southwest courts, which really need that sort of access.
It's not the same. It's not the same from courthouse to courthouse in Northern Virginia.
Oh, okay, all right.
Oh, no, there's no technology.
Okay, I just hear about Fairfax, that's all.
Oh, yeah, no, we're not Fairfax.
Okay.
Or Falls Church, or
Okay.
Arlington,
Okay.
or Prince William.
Powhatan, I had a legal aid client.
You're saying it right.
With them, I know, I learned from you. With a mortgage problem, and it turns out they have no land record almost no land record information electronically. I went down to the clerk's office and they did basically a search for me.
Books out?
Yeah, they did a search for me while I was there. This was 6 months ago. This wasn't 20 years ago. This was 6 months ago. Yeah, it's
Right,
like,
but you
okay.
have the drawers and
But if you're talking about access to justice, a child who's the subject of an abuse and neglect, or parent who's been accused of that, should access justice in the same manner that a child in enrichment. Or let me put a finer point on it. A child or family or support or relative, you have a limited mobility grandparent who can't make it to the courthouse, can't get up the courthouse steps in Alexandria, right? Can't physically get into the courthouse, right? So that case, and let's say the family lives right down the street in the Chirilawa neighborhood, okay, right here,
Mhm.
right? And they have to get in person, the respondents. But if they lived literally across
Arlington.
Glebe Road, right? not only can they participate in these life-altering proceedings as needed, as approved by the judge, but managing technology is different than not having technology, right? And their experience and outcome is totally different. And instead of having to go to court without representation, the attorney who can take a case, but not for the 5-day hearing in 12 hours, can take the case, but in 12 hours has to be someplace else, but is willing to do it if they can participate remotely. And so that, to me, is the cornerstone of access to justice, isn't it? Access.
Equal access. Equal justice under law. It's printed on a building in Washington.
Oh, it hasn't
The
been
pursuit
changed.
of-
At least last time.
Life,
No, no.
liberty, the pursuit of happiness.
It's done and done.
Yeah, I think.
I'm done.
Anybody else have anything they want to say before we turn off the technology here? Good, let's eat.
Thank you.
Thank you.
all.
Thank you all.
very
Thank
much.
you all. I appreciate it. It's been helpful and scary.
Job was not done.
So while I'm thinking about it though, just Chad, people bringing evidence in on phones or iPads or whatever.
Discretionary as to the judge.
So usually what
Yeah.
happens is they have to lock, so you can't bring your phone in, so you lock it up at the front, and then you have to, when you are called, tell the judge, my evidence is on the phone,
No.
and they say, okay, you can go get it, and then you have to walk all the way to the front, get your
Yeah.
phone, which means you have to leave the courthouse.
But some
Right.
judges won't accept it.